Hello and welcome to the Husch Blackwell Labor Law Insider Podcast. I'm Tom Godar, your host, and I'm glad that you've come along. In this podcast, we welcome guests with practical expertise and experience regarding labor law issues, and they share their insights related to this ever-changing area. The breadth of developments in laws related to unions and individual workers' rights that we are experiencing under the Biden-appointed National Labor Relations Board and led by General Counsel Jennifer Abruzzo is unprecedented. These developments demand that employers and those giving counsel to organizations stay tuned into these changes and make necessary adjustments to their practices and to policies. When President Biden was elected, he promised to have the most union-friendly administration ever, and he is fulfilling that pledge. So buckle up and hang on for this wild and wonderful ride in the world of labor law.
This is Tom Godar for the Labor Law Insider, and welcome once again, sports fans. Now I've gotten to do it twice. This is our continuing podcast regarding the Dartmouth University basketball team decision to unionize, a pretty unusual circumstance. We had a lot of fun in the last podcast, which I hope you listened to, talking with Tyler Paitko, one of my partners from our California part of the world, and as well as Jason Montgomery, who practices out of our Kansas City office. And as we finished the last discussion, Tyler had shared with us, as well as Jason, a good bit about why the NLRB thought that maybe a basketball team, not maybe, certainly a basketball team, can be unionized. And what I wanted to do now is find out a little bit about where that goes. Does every basketball team, every athletic team, do orchestras or bands get that opportunity to become a union organized unit within a university or a college? I don't know it's going to go that far. And to turn to that and open our discussion, we're going to pick up where we left off, and we're going to hear from Jason Montgomery as he gives us some thoughts about where some of the lines are on this organizing of college athletes and maybe others. Jason, take it away.
Well, it begs the question, is this a basketball specific or maybe even football and basketball specific issue? Because there is a quote that I found really interesting because, there's this argument by Dartmouth that, hey, what about all our other extracurricular activities? You mentioned band, how are we supposed to differentiate these? And this was an interesting quote, and it was, major media outlets do not pay for the right to broadcast and distribute video of the vast majority of those activities, which is kind of the adage, you're not paying for someone to do a chemistry experiment to watch that. But there's some value in that chemistry experiment that the institution actually may take and move forward with. So it's an interesting way to look at it, but it does seem to me that if I were another small school or a school that is not Division I in particular, I would look at that rationale and say, this isn't us. You're really stretching it if you're trying to apply this to other small schools.
So we don't know, Jason, whether or not this decision would apply, for instance, to your alma mater, Baker University, where you played football, as a small WIAA college, or whether this is going to be applicable to almost any and every institution or subset of an institution where there's control and some sort of benefit to the athlete as well as to the university. We do know that states might move towards this as well. Right now, the public sector is usually generating their own rules, regulations, and laws regarding public sector organizing. And so do we see or do we anticipate that there's going to be pressure placed on the public sector, on the state legislatures and the governors and so forth, to look at whether or not athletes ought to be considered eligible for union membership at the state level?
I'm mostly familiar with the board being the most aggressive in this area. And I'm curious, this is Jason's world dealing with NCAA regulated institutions, what the word is on the street. Are there organizing campaigns underway? I'm just not aware of anything other than the USC case where there was that joint employment theory that brought in the NCAA and Pac-12.
So there was some California legislation that has been paused that would have required some revenue sharing. And probably the best example of this is in the antitrust context, whether it's illegal for schools to cut student athletes out of receipt of the proceeds of television deals, for example. That's being litigated right now in House versus the NCAA in the Northern District of California. So, in the labor context, I haven't seen legislation. There has been, like I said, the California, and there's been an Illinois bill that talks about the structure for workers' compensation for athletes as traditional employees. There's an FLSA case, the Third Circuit, that's pending, Johnson versus the NCAA. So there's a variety of different entities that are looking at this, and plaintiffs' counsel that have brought actions on behalf of student athletes to challenge the common notion that college athletes are not employees of their institution.
And we know that there's strikes are very seldom undertaken in baseball and football and basketball. And we also know that it's the entire league employees that form a single bargaining unit. So we're in a funny place here. It'd be hard to imagine organizing all the Pac-10 athletes or Big Ten athletes or whatever we're going to call these things as we get down to the Big Five, right? But those are not, in a generation, I think that we'll be looking at how that's going to shake out, won't we? Maybe not in 2024, 25, but we're going to look at that. But in today's world, what kind of cautions, what kind of considerations might we offer to our friends and clients that tune into the Labor Law Insider podcast? What sort of lessons do we learn from this and some of the other emerging activities that are taking place on campus? I'll give you a shot to start with, Tyler, and then we'll run off to you, Jason.
So, based on this decision, which of course is being appealed to the full board, there are some concerns that if it's allowed to stand by the board, and who knows what'll happen in November 2024, we may get a brand new board in to change the direction. But if it stands, employers, universities, colleges, small schools have to be aware of the protections under the Act given to employees. If their student athletes, scholarship now or not, are deemed employees, you have to worry about Section 7 rights, and those athlete handbooks will be viewed as employee handbooks. And so if you have provisions in there prohibiting the student athletes from speaking with the media without permission, criticizing the coach or the administration, those would be a violation of Section 7 and could result in exposure for the college or university. I suppose, and I'm curious to get Jason's take on it, if it's not yet the law of the land, so to speak, we don't have a final board decision, we're going to be penalized if we don't retroactively treat people as employees, student athletes as employees. So maybe it's premature to be thinking about that, but I could see that on the horizon. It's hard to avoid reading this decision, just the way that colleges and universities, and I was trying to translate this to the Big Five conferences where there's even more control than at Dartmouth. It's hard to imagine running them in a different way that wouldn't make them employees under this decision. The level of control, for example, the benefits it's not a direct financial benefit except for athletic scholarship, but it's hard to see how it could be managed without finding of employees. And then it just kind of alters the complete landscape. I worry about unintended consequences, like we can't afford to have a union for our 14, or in this case, I think it was 27 sports. Maybe we're going to disband the wrestling team. We're going to no longer have a volleyball team or a swim team, men's or women's. We have to worry about Title IX, or Jason does anyway. So I worry about that. We're kind of throwing the baby out with the bathwater. I wasn't fortunate enough, like Jason, to be a student athlete, but that it would be a huge attraction, especially with the scholarship and the recognition, development of your athletic ability with some assistance by your school. And now I worry that that's going to be completely changed. The landscape is going to change completely if this decision and decisions like it continue.
Any thoughts that you have, Jason, on that same area? What you'll be looking for? And when you look around the corner, what are you starting to see?
I appreciate you bringing up Title IX because I think that's a good point. Title IX is not going anywhere. And so, fundamentally, the question is going to be what can be supported within the Title IX framework if you also have to pay additional compensation to athletes. And if you pay additional compensation to athletes, you have to pay equivalent compensation to women's athletes as well. And that's an open-ended question whether Title IX was meant to address that. So that is a concern for people that have fought for equity in college sports. And the Ivy League in particular has been one that has offered a variety of sports, maybe even non-traditional sports that, like you said, I think, anywhere between 27 and 35 sponsored sports at these Ivy League schools. So that's a problem. In terms of what, colleges are already looking at, universities, they're looking at how they are engaging with their student athletes. From one thing that's mentioned in here in the opinion is touches on name, image, and likeness, and the requirement that athletes have to sign over their likeness to the institution and Ivy League to be used for promotional purposes and so forth. And that's pretty significant. And what I have at least cautioned some schools, especially in the last 3 years when this idea of NIL came out, was that you really do need to give an option for your athletes to opt out of that at a minimum, because they now have a property right in their likeness. Clearly, there are some, the board here and courts and other places that are inclined to make findings and utilize the fact that they are being required to execute and use their likeness on behalf of the institution without any compensation as rationale for them being deemed employees. That's one aspect. And to Tyler's point, though, about the Section 7s, some of those also apply to public institutions by basic First Amendment requirements, which allow, athletes at public institutions to, have free speech about their activities at the institution. As these issues continue to arise, this concept of the ability for schools to manage their athletes in a certain way needs to be rethought and reconsidered and really evaluated from a couple different perspectives. Not only what's in the best interest of our brand as an institution, which is what had been the driving force, as to what's in the best interest for us as an institution to ensure that we're following what is the law and what could be the law in the future.
Well, folks, when we have a $1 trillion industry, and the athletes are both the product as well as the process for that, there's no question that there's going to be continued review of this at both the sort of state school level as well as the private school level. And I think it's a little bit sideways when it comes out at the National Labor Relations Board, by the way. I think that they grasped hard to find this. But I think that over the next several years, it's going to be fascinating to watch what takes place, that nexus between athletes, athletic programs, and the university. And one place that we're going to see it is in this unionized context. So guys, it was really fun to talk about this. I hope that our audience has enjoyed this just as much as I have, because it's really great to hear your insights and your thoughts as we move into March Madness. I think that's what we'll call this podcast, March Madness. Thanks, gentlemen, so much.
Good title.
Yeah.
Thanks, Tom.
Thank you.
Yep. Bye-bye now.